there's a very interesting question being raised online about whether he should have recused himself from this case to begin with. And I'll tell you, I've got my own questions about it. Laura Loomer, who, she's said some things that are not true and that are conspiratorial, but she said a lot that is true. She is not wrong just because she's controversial. And we'll find out. We'll update the audience. But she went, and we believe what she did is she looked at his confirmation hearing to see what he said about himself. And it looks to us like at his confirmation hearing, he did confirm that he had 2 daughters, twins, one of whom is named Catherine. It looks like Catherine's age right now would be 24 or 25. And that dovetails with the picture that we have of the alleged Catherine Roseberg, who is being accused in this exclusive thread by Laura Loomer of working for a 501c3 called Partners for Justice, which gives criminal, illegal aliens and gang members legal advice. Partners for Justice strongly opposes mass deportations and legislation targeting members of criminal gangs, and has been a vocal critic for the Laken-Riley Act, Loomer reports. You can see in a screenshot she posts that Catherine Boasberg, and we think it's the same Catherine Boasberg, but that does need to be confirmed, but Boasberg's an unusual name, and it's spelled in both cases Boasberg. Tweeted out an article celebrating Judge Boasberg's blocking Trump's deportations of Venezuelan gangbangers. And this would be Catherine Boasberg's boss. She tweeted out, her name is Emily Galvin Almanza. That was rightly quick. Trump administration live updates, judge orders halt on deportations of Venezuelans under wartime law. The problem here potentially is that this judge's daughter could potentially be hurt in her employment by a substantial reduction in crime rates, in caseloads involving that keep Partners for Justice busy, relating to gangs and deportations. And so there is a possibility that this judge inappropriately sat on this case, or at least violated an ethical canon by not disclosing that his daughter has an active role in protecting gang members and illegals from deportation. Let's just start there, Rich, with all those qualifiers. Your take on it.
Well, let's put a pin on that and see what the facts are. He is a Obama appointee. His view of the law, Constitution, not mine, but he has a pretty good reputation. Now, this case, it involves a couple things we've seen before. One, the Trump folks kind of rummaging through current statutes to find things that give them the authority they want to do on deportations or on the border. This was quite effective in the first term. There was a migrant crisis, small scale compared to what we saw under Biden. In Trump's first term, Trump was tearing his hair out. How can we possibly stop this? You had Stephen Miller and others going and looking at current authorities and using them in a creative and lawful way to create the system that Biden then ripped up. But that had succeeded and basically stopping border crossings. Now here, they're going back to the 18th century, and there's nothing wrong with that necessarily, right? 18th century has a lot of good things, including the United States Constitution. But it also involves what we were talking about in the first segment, determination by the President of the United States, what national security is, what's an invasion, whether we're at war. And here, I do think they're pushing the envelope. Maybe they're banking on, maybe they'll be right. The Supreme Court ultimately will just say, look, you're the chief executive, you're the president. You say it's an act of war, these gangs coming into the United States. We're not going to contradict you. But I'm not sure that's going to be the case. And what the judge is asking here basically is just to freeze things in place. It wasn't like Judge Ali, in one of those early USAID cases, say you got to spend all this money, billions of dollars of money in 36 hours or whatever it was. It's just let's hold these people so at least I can hear the merits here. So on this one, I wouldn't have gone to war with him, but they have.
I think, Charlie, that you and I may disagree on the propriety of Judge Boasberg holding the hearings on this and thinking that he can second guess the Trump administration on this. And that's fine. We can get into that. But my own position is, if you look at the wording, first of all, let's understand this. Trump has already changed expedited removal. They've already expanded the scope of expedited removal. So let's table for a moment the Alien Enemies Act. Expedited removal has been used by all administrations in certain cases to just return people at the border. Get out. You crossed over. Congratulations. You swam the Rio Grande. Goodbye. I don't care. Get out. We can see that you're an illegal and you sneaked in here. Goodbye. Well, he has expanded the use of expedited removal. It used to be within 100 miles of the border and 14 days of their arrival to anywhere in the country against any person who's, quote, undocumented, who can't prove they've been here for continuously 2 years. All right. So Trump's already done that, saying that's how Tom Homan's going into these communities and saying, you're done. You're out. I don't have to give you a hearing. You're just leaving. Now, some have had hearings and just decided to stay because even when under the Biden administration, they had hearings saying you have to leave. You don't qualify for asylum. We never enforced it. We just turned them back out into America and let them live here. So those people are also being ejected. And those might be some of the people who are on one of those planes Trump sent to El Salvador. At least that's what the administration's claiming, that they're not all ejected under Alien Enemies Act. Some were ejected under good old-fashioned immigration laws. They'd already been told to leave and they overstayed. Okay, so in any event, if expedited removal can allow Tom Homan to go grab somebody in Colorado and kick them out, why is there any controversy over this at all? Why are we even arguing Alien Enemies Act? That's my number one thought. My second thought is, okay, but we are. The administration has said Alien Enemies Act 1798, it's a law that was written by the very founders who drafted the Constitution, applies. And that law says if there's been a declared war or if the country is suffering from an invasion or an incursion by a potential enemy's force, the president has the authority to deport the people associated with it without due process. It's really what it says. There's no hearing required. You can just throw them out. And Trump is relying not really on the war. He's relying on invasion or incursion. And if you look at the statute, which I did pull, invasion or incursion, how do we determine? Like, obviously, act of war declared, that's by Congress. You have to look to see if Congress had declared a war. Invasion or incursion says as declared by the president. So the enabling statute here, passed by Congress at the time of the founding fathers, says the president gets to decide whether it's an invasion or an incursion. And once he's declared that, which he has here, he may deport people without due process, which is why I believe he was well within his rights to do what he did. And I think the rest of that enabling statute, Alien Enemies Act, kicks in, which says there is no power of judicial review under these circumstances. Now you go.
Well, a few things. We're talking about the Alien Enemies Act because Donald Trump has invoked it. In other words, he has conceded by doing that he needs a power to be conferred upon him by Congress, and that's the one he's chosen. The law in question, as you say, has two sections. One of them refers to a declared war. Now, you said that the invasion had to be declared by the president. Is that the word, declared, or is it announced? Either way,
I'll look it up. I'll give it to you.
The argument that was made by
he must
Miller,
the president must make public proclamation of the event.
Exactly. And that matters, Megyn, because there is a difference between declaring a war, which is a congressional function, and proclaiming something, which can be an action done by someone else. Now, I don't know the answer to this. I'm not pretending that I am the oracle, but I do know this. The act in question has been invoked only 3 times, and they were all during wars that were declared by Congress. In 1948, this law went to the Supreme Court because 3 years after hostilities had ceased with Germany, Harry Truman, who had become president after Franklin Roosevelt, was still using the Alien Enemies Act to expel Germans. Now, the Supreme Court looked at it and they said that the decisions of Harry Truman were non-justiciable. In other words, that the courts could not get involved. But that case did not address the invasion clause that you mentioned. It only dealt with declared war. At the time in 1948, Congress still had a declaration of war active against Germany. That was not repealed until 1951. And what the court effectively said is, this is a political question because there was a war declared, because there was a war fought, and because that war created all of these offshoots and consequences, it would be wrong, I think this is correct, for the Supreme Court to determine when the war was over, especially given that Congress had not done that itself. They have never had a decision that related to the invasion clause. Now, it is possible that if they did, they would find that that was also non-justiciable and the determination of an invasion was solely up to the discretion of the president. But to get there, you're going to have a court case. And the core argument that is being made here is that it was inappropriate for this judge to get involved in this, given that the issue is or should be non-justiciable. But I don't think that that is obvious at all. If we're going to find out that this is non-justiciable, we're going to have an argument about it that probably goes all the way up to the Supreme Court, which is what I think we are now seeing happen. So I'm not upset about this. I would also note, as Jack Goldsmith pointed out, that even in that 1948 case, there were some elements of the law that the court said were within its purview. For example, it said that the court was allowed to decide whether or not the people who were being deported fit the bill. Were they old enough? Were they enemy combatants? And so on. Not whether or not there was a war, not whether or not the law could be invoked, but whether the individuals in question were appropriately set. And I think what you're seeing here is the judiciary saying, hang on a minute, we're dealing with individuals. The Constitution protects due process for persons, not citizens, in all manner of ways. There is no obvious precedent here. We need to litigate this. And you can't do that when a plane is in the air and it's on its way out to a high security prison. So I'm less upset about this. Now, do I think that the vast majority of the people to whom this is being applied are likely terrible, terrible people? Yeah. Do I want them deported? Yeah. Would I like to get rid of every illegal immigrant in the country? Yeah. Would I like to get rid of these ones in particular via a trebuchet? You're damn straight I would. But the argument here, I think, is different than the argument that I've made and you've made about the vast majority of these solitary judges who have tried to impede the Trump agenda. Most of those are doing so with no basis in the law whatsoever, basically out of political animus. And this is not the case here. So I have more time for this one than you.
I have a problem with this judge. I don't agree that he can debate the propriety of the individual. I really don't. I think once you determine that it's a male from Venezuela over 14, right, it's not for him to determine whether they're a gang member or not. That's up to Homan and Trump.
But the court is allowed to do that bit. That's what the Supreme Court case is. The court's allowed
for sure.
To determine
and even the
if
DOJ has acknowledged that. Even the DOJ in its filings has acknowledged that there is a very bare minimum of inquiry that this judge is allowed to do, but they're arguing that he far exceeded his remit. And the notion that an unelected federal district judge could turn around two planes in the air carrying gang members from Venezuela out of the United States. Again, Stephen Miller raises some very good points without knowing what the fuel supply is, without knowing what the wake time hours of the crew and the pilot are, without understanding whether there was a safe place for them to turn around in international airspace. The hubris of this man to think he could do it. And by the way, he's making a big deal out of the fact that he issued an oral ruling early Saturday saying, don't let those planes take off. And he didn't write it down until later in the day. And he thinks they should have complied with the oral ruling. But if you actually look at the rules of civil procedure, there is a requirement that you write down, especially when it comes to TROs, that you write down what you're mandating. So I think that's why ultimately the judge abandoned what had been done after his oral ruling. But the left-wing media won't tell you that. They ran with, he issued the oral ruling early in the day. No,
but
the one that governs is the written ruling. Go ahead.
But how else do we litigate this? I mean, you've got, on behalf of the plaintiffs here, you've got two statutory claims and a constitutional claim. And maybe the Trump administration will prevail, and maybe it should. But the people in question, although, again, I'm sure most of them are terrible, are allegedly in this gang. They have been accused of being in this gang. If you are a judge and this comes to you and you don't have a definitive Supreme Court ruling on this because of the distinction between declared war and an invasion, and you have two statutory questions being made, plus a constitutional question, does the act in and of itself violate due process when used in this way? I don't know what you do other than involve yourself.
But you're saying the distinction between declared war and invasion in a way that would undermine the Trump administration's argument right now. It only helps. It only helps the Trump administration's argument right now. Declared war would undermine them because they don't have a declared war against Venezuela right now, not by Congress. But incursion or invasion, as I read to you, the statute says the president makes public proclamation of the event. That's all that's required. The president makes public proclamation. He did that. You don't go out and buy a life jacket when the boat is already sinking, and you don't buy gold when the economy has already collapsed. Clearly, others are heeding this advice as gold hit all-time highs already this year. It's not too late for you too, and you could have Birch Gold help you diversify into physical gold. Birch Gold specializes in helping you convert an existing IRA or 401k into a tax-sheltered IRA in physical gold for no money out of pocket. One recent 5-star review said Birch Gold was, quote, knowledgeable, helpful, non-pressure. Get your free info kit on gold by texting the letters MK to the number 989898. There's no obligation, just useful information. With an A+ rating from the Better Business Bureau and countless 5-star reviews, just text MK to 989898 and let the experts at Birch Gold help you secure your future today with gold. Thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.